Welcome to SIIA's podcast on what you need to know in 10 minutes, the TC Heartland versus Kraft Foods Group brand case that the Supreme Court decided on a week ago. I'm your host, Niko Marcich, and today I'm sitting down with our legal counsel, Christopher Mohr. Chris, thanks for coming on.
My pleasure.
And today we just want to talk about why this case is important, what actually happened, and how SIIA played a pivotal role in this big victory for our members. So going into this case, what actually went down in the TC Heartland versus Kraft?
The case involved Kraft suing TC Heartland over a patent in Mohr on the theory that the defendant was selling infringing Mohr products, or rather infringing products in Delaware, and that Delaware was a good place for them to bring a lawsuit. But the defendant was organized in Indiana under Indiana's laws and was headquartered in Indiana. So then what happens is, okay, the complaint gets filed. The respondent says, this is a wrong place. Let's transfer it to Indiana. The district court says no for a variety of reasons. And then TC Heartland appealed to the Supreme Court, and here we are. The holding has pretty big implications for our members who are facing that kind of problem.
So, Chris, can you tell me why is this case so important?
Well, on a practical level, what this case is about is if you're a patent owner and you think someone's infringed your patent, where are you allowed to sue them? There are two kinds of statutes that apply in this circumstance. One is the general venue statute, which applies to every case brought in federal court, and a specific statute targeted at patent cases alone. The question in this case was which of those statutes controls. Common sense would tell you that, hey, if there is a specific patent statute, that ought to be the one that controls patent infringement cases, particularly if it's a venue statute. And it could be as simple as that, but unfortunately it wasn't. Before 1988, the word reside meant, as applied to a corporation, where they were incorporated. After this minor amendment to Section 1391, the word resides got a new meaning, and it meant anywhere you could get what's called personal jurisdiction over them effectively. In other words, anywhere they could be quote-unquote found in the country, which for a national firm means anywhere in the United States. And as a result, a recent study showed that 44% of all patent lawsuits ended up in the Eastern District of Texas. And of those lawsuits, 90% of them had to do with telecommunications technology or software. This is a direct assault in many ways on our members by the entities that were bringing these lawsuits.
So a lot of these entities, from what I've been reading, are what we refer to as patent trolls. Could you explain quickly what exactly are patent trolls?
First, they are uniformly non-practicing entities. They don't make anything. They just hold intellectual property, and they look to monetize it, typically through litigation. The second thing is that those patents tend to be in software or network technology. That's where the problems are plaguing us.
And specifically in this case, why did SIIA file an amicus brief?
Well, I think there's a bunch of ways to answer that question, but the best one is probably to start with what an amicus brief does and why we file them. The purposes of an amicus brief are to enlighten the court on things that they might not otherwise know based on the four corners of the case. So here we had a case involving food flavoring that was not in the Eastern District of Texas. Our concern is not with patents in the food flavoring industry. Our concern is with technology patents, particularly those involving telecommunications and software. And this was an opportunity for us to, one, explain to the court all of what we perceive to be the bad effects of the Federal Circuit's unwise venue rule, and two, to guide it on both a historical and policy basis towards what we believed was the correct and far more equitable result of returning to the definition of, quote, resides, close quote, that existed in Forco.
So now, can you just tell us what the broader implications are of this case?
Sure, it means that things are going to get lonelier in the Eastern District of Texas, but not immediately. So I think for certain kinds of companies, certainly for let's take let's suppose it's a Silicon Valley company that doesn't have offices in Texas, or an app provider, or someone like that. This is a great decision for them because it gets them somebody who's located in Silicon Valley and has only one office, but makes its things available worldwide from that office or its server farm there, or wherever its server farms may be, is not going to see the Eastern District of Texas. Somebody who's selling tires in every state and happens to have a location in the Eastern District of Texas could very well be back in that same court under the second prong, which has not received a lot of judicial attention, but I think it's fair to say is about to receive a lot more.
Mm-hmm. How could Congress actually respond to this Supreme Court case?
Oh, any number of ways. So one of the things that's in the draft legislation in the Senate has to do with certain disclosures that have to be made about who's funding a particular patent lawsuit, for example. Those would have to be created by or mandated by statute. The second thing is that there are two prongs to the patent venue statute. One is, all right, judicial district where the defendant resides. We know if it's a corporation that it resides where it's been incorporated. We also know, because the court told us, that if it's a foreign corporation, in other words, somebody, an Italian corporation who's doing business in the United States, they can be sued anywhere in the United States. And we also know that if we're talking about things like an LLC, that's going back down to the lower courts to be figured out. So this doesn't answer every question. Congress could answer every question when dealing with venue. The second thing we don't know that Congress could answer or flesh out for us, because otherwise the courts will do this, is to address the second prong of the patent venue statute, which allows lawsuits where the defendant has committed acts of infringement and has a regular and established place of business. What does that last phrase mean? So, okay, you can always sue a particular, if it's a public company incorporated in Delaware, you can always sue them in Delaware. But if they have a retail store, suppose it's a nationwide retail chain that is selling an infringing product, they are potentially still subject to the same problem. And that's a problem that only Congress can fix.
So from the perspective of our members, now that this Supreme Court case has gone down, if you get sued via patent infringement, what should they do? What can they do?
All right, well, the first thing that they need to do is early on, and by this I mean when you get the complaint, right, your first response is an answer or a motion. If there's any chance of getting out of the Eastern District of Texas, or you think they've sued you in the wrong place, you have to lodge that objection immediately and early in the litigation. It's something you need to preserve, because you can waive it. The second thing is, if you haven't been sued in your state of incorporation, you have pretty good grounds to get out of wherever it is you've been sued, unless it's obvious that you fall under the umbrella of that second part of the venue statute. In other words, is it a place where you've committed acts of infringement and have a regular and established place of business? Both of those elements have to be met, and it's a really good idea to examine whether they exist when the lawsuit comes over the transom.
Mm-hmm. So both of those will be extremely important for our members moving forward.
I think so, probably, yeah.
Right. Well, thank you, Chris. Thank you for that interview. I thought it was fantastic, and I'm hoping that our audience and our members learned a lot about the TC Heartland versus Kraft Food Group case. And if you have any questions about our Amicus brief program, please feel free to reach out to our very own Chris Mohr at cmohr@SIIA.net. And thanks for tuning in.